Hi, I am Sarah Boone, self-appointed Esquire and legal authority under Florida law, and I am here to explain my latest motions. I appreciate you inviting me here because I think that everyone needs to be made aware of how I am fighting for justice. But I need to get a little bit ready for this because I have a whiteboard for those of you ill-informed conspiracy theorists that want to, misjudge my case. I can't believe you. I'll spell it out for simple people for you for this. But let's see here. Also, I was told I couldn't wear a judge robe, but nothing is going to stop me from honoring the late and great RBG. Rest in peace. I'm fighting for justice just like Sandra Day O'Connor and Ruth Bader Ginsburg. I really am a saint. I've suffered a lot. Let me get my coffee ready and we'll be ready to go with this because I have some motion-splosion to explain. Not that I get any help around here or that the judge knows what he's doing, but okay. And I see you're all here, so let's get started. Just terrible. Just absolutely terrible that I would be reduced to representing myself because the state of Florida has no ability to pick defense attorneys with decorum. I just can't. It's terrible. Anyway, I had to write this with a pen nubbin. Do they tell you that? They don't even give me real pens. I am fighting for justice and peace and Jesus and Dr. Pepper and the right for everyone to have their smokes with them. And most of all, hair gel. Hair gel. Anyway, let's get to my motion because I am legalified. It's about to get lawful law in here, and I'll be able to explain everything. Anyways, thank you all for joining. We've got Sarah Esquire in the building. I can only imagine what these motions are going to show, but she has better handwriting right now, so let's see. I'm sure it will deteriorate at some point. In the Circuit Court of the Ninth Judicial Circuit and for Orange County, Florida, State of Florida plaintiff versus Sarah Boone defendant. Bold and capitalized, which means pay attention. I don't understand because I can't, do things, but capital letters and underline mean important in Sarah land. You all would be good to know that. I don't know why the judge refuses to listen to my private emails explaining to him how to law. I have Black's Law Dictionary, 1984 edition. I know things. I was a high school honor roll student, damn it. And thank you, Wolfram, for gifting 5 memberships. And those went to Kim Farnham, Alice G, Femme Fatale, Roy Longsinger, and Stacy G. So congratulations. Welcome to the Church of Mo. We have dark chocolate and sarcasm, but no patchouli oil or recorders because, holy God, those things are audio assault weapons and should be banned. When I'm president, recorders will be banned. You're welcome, America's parents. Motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. I mean, I don't know what I'm expecting since apparently every time that the judges point their darts of justice at the board, they keep giving me duds. I keep telling them, I keep asking for a manager. I've almost gotten to DeSantis. I think my letters are being stolen because people care so much about me. I don't know, but I need help. I am not a lawyer. Comes now Sarah Boone, pro se indigent defendant. Indigent, but still independent and a strong woman. Don't you forget it. Respectfully request from the court immediate relief by providing effective standby counsel with all legal services allowed and included to assist, and aid the defendant as a whole in the complex vital procedural preparation with professional guidance during her forfeited right to counsel by the court as pro se attorney and her proposed lawful representation of self in her criminal case. It really is unfair. I have done nothing but tell those lawyers exactly how to lawful law. I mean, really, I shouldn't have to employ a fake judge or, you know, tell these people how to legal. I thought they were here to work for me. And every time I try to call them 6 or 7 times a day, they don't answer the phone. It's embarrassing and unprofessional. Unprofessional. Defendants' justifiable reason for requested relief and assistance are as follows. 1. The defendant's sixth constitutional right to counsel is being violated. And you know what I'm worried about? I'm worried about, most importantly, my rights being violated. Unlawfully withheld and forcibly removed from the indigent defendant under false pretenses, speculation, and libel misconstruction. Just terrible. By the defendant's lawful practice of her entitled first constitutional right. So Mr. Judge, we have my Sixth Amendment right and my first. Now, I don't want to tell you what these mean, but I have written them down and underlined them, and they are very important. See my previous letters and correspondence. First constitutional right of free speech and her God-given, and believe me, God loves me. God loves Sarah Boone, okay? And he doesn't like how you guys are treating me, and there's going to be issues, okay? Uh, by writing her experience, derived the truth, and providing quote unquote red flag exposure in her correspondence to the court requesting needed intervention to avoid present circumstances. Again, I tried to call their managers and no one would listen to me. I tried to call the president. This is my Ruth Bader Ginsburg doily necklace. Sarah's fighting for truth and Ruth Bader Ginsburg. Look, it was funny in my head, but now it's actually, I feel like I'm choking, even though it's quite loose. I don't like collars. Boosh, I'm just wearing something to see if you're paying attention. She has lost completely her ability and advantage to properly, rightfully, successfully prepare her defense of innocence, progressively advance faithfully and unrestricted, while having the ability to be leveled equally with the prosecution. Sarah, sweetie, sweetheart, you would probably do better if you threaten the judge to define and send a long and torturous letter of the definitions of all these words that you're using in a word salad that would be, uh, well, complimentary of many politicians lately. They were a totally loving couple, and my mom, Peppermint Patty, and Velma are doing just fine. 2, the defendant is not an officer of this court or any court or legal system as a whole. She is not bound lawfully under oath or certified in any professional means to be or act as a legal agent or representative, lacking requisite professional competency, experience, expertise in the field of law presently and historically. Well, I mean, Sarah, Sarah, you had 8 people. Now 3 of those people had to resign because, you were Well, Jorge was a former client of theirs, but 4 of them you were just an insufferable, well, dingleberry to, and they couldn't stand you. You are single-handedly, I think, responsible for the rise in bourbon sales in Florida of lawyers. The defendant is defective and ineffective. If that had been just the full sentence, that would have been awesome, but it continues. Counsel to self as a result, which therefore will detrimentally impact and impede favorable justice to the defendant and the opportunity of a fair trial based on equality with a unprejudiced conclusion of her case. Yeah, I mean, people have already twisted my case and, maligned me, and they don't even know me. I mean, I could annoy the entire world, but I'm just limited to Florida right now because I can't get out of jail. But I mean, honestly, I could just annoy the entire world. It'd be fine. It's not my fault that you guys are haters and, confused cat meme over here. I'm just wondering why you hate me because I'm beautiful and smart and you're jealous. Don't be peanut butter and jealous, world. 3, the defendant is presently incarcerated, Godoy, which is causing and will cause unfair burdens, limitations, deprivations, inaccessibilities, and unequal opportunities in and to her ability to complete tasks and timely responsibilities suitable to the vital defense of the defendant's life and livelihood futuristically. Dear God, do I love her use of the word futuristically? I've never heard it except in a Sarah Boone letter, and I just might get a bumper sticker that says futuristically unintentionally or unintentionally futuristically. I don't know, but that might be my favorite Sarah Boone word of all time. By the court rejecting professional, educated, experienced, and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be averse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Examples of said unfair burdens, limitations, deprivations, inaccessibility, and unequal opportunities include. I just can't do she just has this terrible face all the time, like, it's just weird. I'm trying. Do you know the hardest thing getting ready for Sarah, aside from the hair, which just takes a lot of gel and hairspray? It's putting on the oblivious to why people find me an entitled, unrepentant, and abominable soul. But just that entire, self-confidence in the spite of her inability to function as a human being. I I don't understand how she does that, but it is quite interesting to try to get in that headspace. A, the defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. I mean, I am my own lawyer. I am now Sarah Boone, Esquire, third-party intervener, Black's Law Dictionary, citizen under God, Amen, Esquire, doubled. How dare you not give me my defense? Now, the star is where I would use highlighter, but apparently I'm not allowed highlighters because I am deprived. With only 4 days to submit my demands and motions delegated by the court on or before 7/22/24. 6, the defendant has not reviewed from the court to date of this motion any of her promised discovery or case-related material submitted by former attorney. Yeah, the one that was problematic. Yeah, your dart of justice missed big time with Miss Cashman. Were you blindfolded, Judge Krasinski? Is that what happened? Were you playing, Russian roulette with my future? How dare you? How very dare you? Again, with only 4 days to submit my demands and motions delegated by the court on or before 7/22/24. C, the defense does not have access to a computer. I don't even have YouTube. Defendant doesn't have access to the internet. The defendant has extremely limited irregular access to basic tablets supplied by the OCCD. I mean, every time I ask for them, and I always ask for them, but it seems like they just purposely miss me. I raise my hand in everything, and I have asked to talk to the manager of the jail because I am lawyering myself. I am lawyering all by myself, and you'd think that they give me a pad, but no. No one cares about Sarah Boone except Sarah Boone, and I will keep fighting on for myself because I am a brave warrior for me. The defendant has access to pay phones for collect calls only, and they're limited to 15 minutes per call. G, the defendant does not have access to organizational supplies or production equipment, copier, printers, etc. I mean, what am I supposed to do here? Do I get a mimeograph? Can I get a Scantron? Is there anything wrong with it? I pay taxes. Where the hell did my taxpayer money go? I mean, I voted for the last president. I have been in jail for 4 years. Where are all my taxes going for those Levi's that I make? Damn it, I deserve a printer. And not a crappy printer, but one that you have the little squeeze bottles and you can put the toner in. I'm a lawyer now. Things are about to get serial. H, the defendant does not have access to a meeting place for privacy in case review and preparation. I mean, do you understand? I need quiet for this miracle machine in my brain to work. I am an exceptional human being, but I need quiet to work. My brain doesn't synthesize, and I'm not Copus Mentis in a bunch of loud prison cells. So you guys are you guys are defaming my ability to speak, and it's imprisonment of my mind, and I refuse to let this injustice stand. I, additional daily obstructions and undermined hardships, disadvantages, difficulties will likely come about due to being incarcerated and once my case materials are finally received. Okay, y'all, who the hell do you think is going to steal all of Sarah Boone's files should she get them? Because I'm sure she's just a peach in jail. I'm sure she is Miss Congeniality and everyone loves her. Can you imagine just someone taking every third sheet of paper out of her files for reasons? Continued application in reasoning and further lawful support of the defendant's request for immediate relief with standby counsel to aid and assist preparation of her criminal case. I like how she low-key shades, like, she's like, Judge, if this was your brain, if this was your head, your brain would be over here. She's like, look, I'm using logic, sir. I'm using logic. And you could logically see this stuff if you were just smart like me, Sarah Boone. Not intentionally smart. I just am smart. That's why you're all peanut butter and jealous. A, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state. By the way, when are we going to get into the jury? Because there is no way that my jury will be untainted. The facts in my case have been misconstrued and misread and misaligned and possibly chiropracted into a pretzel. And it's just not fair. Why does everyone get to know things on the internet before I get to say things? You guys make me so mad. You guys make me so mad, and I just have to I just have to work on my coffee a bit. No worries. I get so thirsty. It's cottonmouthy in here. Have you ever heard? It's dry in jail. It is very dry, cottonmouthy. An impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. I mean, really, I have not even heard why I'm in jail. Has anyone heard me say unintentionally? Because I think I've said that enough. Don't I get out of jail now? I mean, I didn't mean to do this. It's been 4 years. We had a good night. We had a good night with puzzles and painting, and I don't know why Jorge wanted to run away. I just don't. You guys are so mean, and you tricked me into coming into the prison. Oh, what? No, Judge, this is on point. This is totally on point, and I am staying on point. But those officers lied to me. They said that it was an interview, and I was coerced. I was coerced, and I was, I was, yeah, I was coerced with force and duress to confess to things that I didn't do intentionally. And I think we really need to get that down for the record and on the record and run the record back. I have been consulting with Daryl Brooks, LLC, limited liability lawful law instructor. So I think we're going to be good. To be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. Amendment 6, United States Constitution. B. Right to counsel is assured by the Sixth Amendment, which has been incorporated into the Due Process Clause of the 14th Amendment. So, I mean, we already have like a bunch of numbers of amendments. So, I really think that you need to understand that both baby Jesus and baby George Washington are going to be very mad at you if you continue to, abuse my freedom like this. I'm already writing them letters. The 14th Amendment, as well as state constitutions, so that every criminal defendant who faces a potential loss of liberty has access to an attorney who provides effective assistance of counsel at each stage of the criminal proceedings and process. Good Thor, you are huge, Thor. Good, holy cow, that's 20 pounds of cat. Oh. Right to counsel applies whether the defendant can afford to hire a lawyer or not, which, by the way, I was gonna have a lawyer, and I told my ex-husband to get me a good lawyer, but of course he got me a schlemiel. So I don't what's going on. I tell him all the time, I'm like, "Don't make me have to get mad. I'm not good when I'm mad. I don't like to drink. I don't want to drink, but when you make me mad, I want to drink." And then he pushes me to these things. I would have been totally fine had he just gotten me a good lawyer to begin with. But no, he's like, "Oh, I don't want to pay alimony anymore. And I'm tired of supporting you, Sarah. And you don't have a job and you never have, Sarah. And you put our son in a suitcase." And it's all this blah, blah, blah instead of where is my money? I feel like, Tiffany Henyard, pay me my money. Your Honor, I'd like to sue my husband for alimony, please. This isn't the court. You are the court. Are we going to rush to the pulpit here? I want him to give me alimony now. I need a real lawyer. It's my right. C. A waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I haven't ever refused. I just simply critique and explain better legal practices to my lawyers. I provide a service. I am trying to help people with their lives and betterment. I just give them a little pip, a performance enhancement plan or improvement plan, a little pip, you know. And you would think that they would enjoy these critiques of their, profession. And given that I am an intelligent, well-spoken, humble, godly crusader for justice, they would take my Yelp, reviews with grace and understanding. But they seem to get all snippy about it. Is made by a person with full capacity, unprepared, that is knowing and voluntary. I was forced. I didn't even know this was an option. No one told me ever, ever, ever that if I kept going through lawyers, I could maybe lose one. No one told me that. I mean, I remember someone babbling about something. They were in a black judge robe, and I was like, "Get your manager." But I had never heard anyone directly tell me that I could lose my lawyer, and that can't be fair. That really just can't. Let's see. Rejects representation or assistance by attorneys at law during the pending proceedings. Waiver of counsel, Bouvier Law Dictionary 2012 edition. A defendant's decision to waive their right to counsel must not only be competent, but also knowing and voluntary. Maynard versus Boone, 468 F. Dot 3D 66568 10th Circuit 2006. Yeah, I can cite legal cases too. Put that in your pipe and smoke it, pulpit man. Quote, the right to waive counsel forced by the court is a right knowingly to proceed in ignorance. It is sufficient for purposes of both the state and federal constitutions that the record, taken in its entirety, shows that the defendant comprehends that a waiver of counsel means that they will proceed into a labyrinth of law without the assistance of a trained guide. End quote. Quote, the court must first make inquiry into his competence and reasonably be satisfied of it before accepting the accused waiver of counsel. I never gave one. I mean, I'm pretty sure everything's already on the YouTubes now and being used to create money that I'll never see. But yeah, I never said yes to this. So, again, pulpit man, no rush. And, you know, if you don't do knife hands, three fingers point back at you, Judge Kranick. Let's see. Before accepting the accused waiver of counsel, I never gave. Competence means more than a minimum of mental awareness and capability, however, and involves an intelligent comprehension of legal consequences of his act. Thor, you are too big to get. This is not going to. Thor. Fat guy in a little space. Thor, this is not going to work. All right, off, down. Oh Lord, Thor, why? People versus Holcomb, 47 Michigan Appellate Court, 57 or 573 and 584, 1973. I mean, this is just ridiculous. We are not even following basic rules. I didn't ask for special treatment. I asked for good treatment. And I am going to leave this the worst Yelp review ever. I really am. Quote, the trial was a farce or a mockery of justice or shocking to the conscience of reviewing the court or for the purported representation was only perfunctory, in bad faith, a sham, a pretense, or without adequate opportunity for conference and preparation. People versus DeGraffenreid, 19 Michigan Appellate Court, 702, 173, Northwestern 2nd District, 317, 1969. Well, she's picking some oldies but goodies. She's going way back into you know, prehistory, or as Gen Z would say, before 1984. They're like, did you guys have televisions back then? Hair? Ineffective counsel is both a standard of inadequate performance for a lawyer in criminal representation and a failure of due process of the law. I mean, I'm not saying this. This is this is Bouvier's law. So I mean, you don't have to trust Sarah Boone. It's like that reading Rainbow. You don't have to trust me. These people recommend it. A person who has suffered a punishment in a criminal proceeding, quote, I was repeatedly lied about by my former attorney to the judge who is unjustifiably believing all over me, falsely accusing me of an inappropriate and wrong strategy. Again, does the word, not intentional mean nothing to you people? Nothing. Just absolutely nothing. I have told it. I have told people that I am innocent, of removing attorneys who withdraw from my requests to the court for intervention, causing me to be forced to lose my right to counsel from their ineffective counsel. It really is unfair. I mean, I can't imagine why you're punishing me when it's really all their fault. I am never the problem. I have always been a kind, beautiful, sober-ish, mother and wife and honor roll student, even in my 40s. To which there is a right of counsel, but who received ineffective assistance? You're looking at her, Sarah Boone, unqualified legal assistance. I am a murder client, and thus far, none of these, uh, I know none of these lawyers have done a good job. I really blame the education system, ban the Federal Department of Education, because they are just not turning out good lawyers anymore. It's really sad to see. I always had faith in our justice system, but now that I see how it really works, it's just full of incompetence. If they'd had me in charge, there would be none of this shenanigans. Okay. With adequate representation, as long as there is a reasonable probability that the result might have been different if the person had received adequate legal assistance, from ineffective assistance of legal counsel, Bouvier Law 2020 or 2012. Quote, due to ineffective assistance of counsel, the federal courts in 1999 set this second aside, Smith versus Arizona. The Florida Constitution. I mean, could you just read your own Constitution? You're sitting there doing nothing but judging. I mean, what are you doing? It's not like I write you a letter every week. You shouldn't be busy with just my case. I'm a client too. Your judgeship. Article 1, Declaration of Rights, Section 2, Basic Rights. All natural persons, male and female alike, are equal before the law and have an inalienable rights, among which are the rights to enjoy and defend life and liberty, to pursue happiness. No one has thought this entire case about my happiness, and I'm just so glad that the state of Florida decided to try to think of my happiness, because that's how I know I live in the best state ever, because I really have a right to be happy. I mean, I know that everyone wants to pick apart my life in misconstrued craziness, but I deserve to be happy. I have struggled enough. I really have. I mean, you have no idea. It's difficult being me, being so much smarter and having to try to deal with dumb people. I mean, there would be many more of you in suitcases, allegedly, if I didn't control myself better. So the fact that I've walked on this earth for nearly 50 years with only one person down, I mean, seriously, can't we just grade on a curve? Section 4, Freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain, abridge the liberty. Thor, there is no food up here. Stop. Dear God. It is apropos that my mug says I work hard to give my cats a better life. Bush McFadden, how dare you? This is Bay Bridge, which I think is a $3 bottle of wine I've had in my refrigerator for at least a year and a half. So Mr. Mo will at least be glad that we've cleaned out the refrigerator. I've sort of got that clean out the refrigerator, chore done. But they are responsible for the abuse of that right, which honestly, I think that I'm going to copyright strike all of YouTube because, honestly, the amount of heinous, vile, and twisted information that's allowed to get out about my case is just horrific. Horrific. No law shall be passed to restrain or abridge the liberty of speech or the press. In all criminal prosecutions and civil actions for defamation, the truth may be given in evidence. If the matter is charged as defamatory, it is true and was published with good motives, the defendant writing truthful, lawful letters to the court requesting help with dysfunctions of attorneys. Is the defendant unlawfully forced to forfeit her right to counsel from lies and misinterpretations and effectiveness from those former attorneys? Retaliation from the court and the party defendant shall be exonerated, given appointed counsel. I think, Judge Kranick, when you look at this with logic and from my point of view, you will see that I should get 2 lawyers and really bail money and bail and to be set free. I mean, really, what are we doing here? Unintentionally. Section 5, the right to assemble. Sarah Elizabeth Boone, I don't know your middle name, but what in the hell are you talking about the right to assemble? Are you going to protest as a protest of one pro se for yourself? I mean, I would kind of like to see a one-woman Sarah Boone protest. I'd like to see the poster she created. But I'm not sure what her right to assemble has to do with any of this, but okay. Section 5, right to assemble. The people have the right to peacefully assemble without harm to instruct their representatives and to petition for redress of any grievances. Section 9, due process. What is it? It's something Sarah Boone would like. I don't know why it's so hard for the state of Florida to give me my due process, but apparently it's just my cross to bear. I shall do it silently as I have been, with great humility and, just faith in God, and a bunch of paper and pens and insufferable letters. No person shall be deprived of life, liberty, or property without due process of law. Hello, judge. Hello. 3-point back at you. Are you doing the law? Are you? Are you taking care of this? No, you're not. You're just sitting there playing blind justice darts. Or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. Section 16, rights of the accused. A, in all criminal prosecutions, the accused shall, upon demand, be informed of the nature of the cause and accusation. I mean, I don't even know why I'm really here, to be honest with you guys, because it was a good night. Like, we were doing puzzles and painting, and I just went to sleep. Shall be furnished a copy of the charges, shall have the right to have compulsory process for witnesses, to confront at trial adverse witnesses, to be heard in person by counsel or both, and to have a speedy and public trial by an impartial jury, which is of course impossible because the YouTubes and the internet have made my case shenanigans. Uh, Impartial jury in the county where the crime was committed. I mean, Judge Wooten and Judge Kranick and all of you, Miss Cashman, and that other guy that I humiliated. Uh, you have made it all impossible. I am going to write a cease and desist from my third party intervener myself because you guys are, violating all my constitutional and unconstitutional right. Frank C. Bankowitz. See, I have current dramatic stress syndrome, and Frank Bankowitz is the cause. Now, I know that people might not have heard of current dramatic stress syndrome, but it involves a person who's been currently in stress and they act dramatic. It's not my fault that I'm dramatic. It's the stress. I can't control it. I have no self-control because of trauma and stress. And currently the internet is it. The 14th Amendment. Oh, access to courts. I almost forgot. You guys have made me so mad. Section 21. Access to courts. The courts shall be open to every person for redress of any injury. I mean, yeah, how am I going to sue the state of Florida? I mean, am I going to get the state of Florida to come into the court because I don't see a person? I don't know that the state of Florida can charge me. And justice shall be administered without sale, denial, or delay. I mean, really, Judge Wooten, if I had $10, would you give me you know, a not guilty? Would you give me some bail? Do I have to have money? Do I have to flash my YouTube subscribers to you to get you to go on the conspiracy? F. The 14th Amendment to the Federal Constitution declares, quote, all persons born or naturalized in the United States are and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny any person within its jurisdiction the equal protection of the laws. This provision has often been construed by the United States Supreme Court, and it has been uniformly held that due process of law requires ample notice to the accused and sufficient time to secure counsel and prepare for trial. A like rule as to the necessity of due notice and reasonable opportunity to prepare for defense is declared in Franklin versus the state of South Carolina, in Rogers versus Peck, in Tooker versus Los Angeles, in Louisville versus Nashville, Rye versus Smith, and other cases. I mean, everyone seems to be fighting for Sarah Boone's innocence. It's like millions of years of jurisprudence have been coming up to save me. The Magna Carta was built to save Sarah Boone. That was the only reason. Quote, such notice was not reasonable one and was not due process of the law within the 14th Amendment to the Constitution of the United States, and a judgment obtained on such notice was not binding upon the defendant. 6 RCL, page 446, states that essential elements of due process of the law are notice and opportunity to be heard and to defend in an orderly proceeding adapted to the nature of the case. Sweetie, Sarah, lovely one, here we go. Ma'am, you have been through due process. You have not been denied due process. In fact, this 4 torturous years of legal ridiculousness in which you threaten every lawyer with, bad Yelp reviews and terrible letters where you comment from everything to their lateness and prior criminal or prior, complaint records, you are the problem. The term due process of law, when applied to judicial proceedings, means a course of legal proceedings. Of course, though, to those rules and principles which have been established by our jurisprudence for the protection and enforcement of private rights, Penover versus Neff, 95 U.S. 714 and 715. I mean, she's making some good points. I'm sure that the judge will be really happy that she used the right to assemble. I mean, I don't know how many people were going to assemble in the Samsonite, but there you go. She is thinking outside the box. She's like, look, Jorge had the right to assemble inside the suitcase, and I didn't want to block that. I'm no tyrant. Uh, let's see here. The accused cannot be, quote unquote, deprived of his life, liberty, or property unless by judgment 298 PA 173 of his peers or the law of the land. Now, the law of the land means like laws that I'm looking up in Bouvier's Law Dictionary 2012. Maybe you should get a copy. Judge Kranick. I mean, I didn't think I'd have to tell you these things, but apparently you're just not as educated as I am. Have you thought about using Google, Judge Kranick? Because I learn a lot of good things. It is vain to give the accused a day in court with no opportunity to prepare for it, or to guarantee him counsel without giving the latter any opportunity to acquaint himself with the facts or the law of the case. Every man is presumed innocent and when accused, entitled to reasonable opportunity to prepare for his defense. Commonwealth versus O'Keefe, 298 PA 169. She just keeps using the same cases. Which, I mean, to be fair, I would totally lose track of what I was doing and just put down made-up cases, to be honest with you. But I also wouldn't piss off a bunch of lawyers and then get myself, removed from legal care. G. Quote, it is true that great and inexcusable delay in the enforcement of our criminal law is one of the grave evils of our time. The prompt disposition of criminal cases is to be commended and encouraged. But in reaching that result, a defendant charged with a serious crime must not be stripped of his rights to have sufficient time to advise with counsel and prepare his defense. To do that is not to proceed promptly in the claim of spirit of regulated justice, but to go forward with the haste of a mob, end quote. An affirmation of the right to aid of counsel in petty offenses and is a denial of case in crimes of gravest character where such aid is needed most and is so outrageous and obviously a perversion of all sense of proportion. Sarah, you might not want to call, uh, you know, the judge an outrageous, mental arbiter and then willing to pervert and, overpunish you. I mean, you catch more honeys with sugar than vinegar, but I mean, hey, it's a bold strategy, Sarah. Let's see how Judge Kranick is going to feel about you calling him basically a legal ignoramus. Recognizing that the rule was settled at common law, denounced as it was not in keeping with the rest of humane treatment of prisoners. For upon what face of reason can that assistance be denied to save the life of a man, which yet is allowed him in prosecutions for every petty trespass? How can a judge whose functions are purely judicial effectively discharge the obligations of counsel for the accused? Well, he can't. In fact, that is why he is not allowed to give you these hints about what lawful law, magic spell you're supposed to use. There in fact, the Darrell Brooks, uh, judge, Judge Dorrell, did a lot more explaining things to Darrell than she really was supposed to. How can it oh, he can and should see to it that in the proceedings before the court, the accused shall be dealt with justly and fairly. He cannot have investigate he cannot investigate the facts, advise and direct the defense, or participate in those necessary conferences between counsel and the accused, which sometimes partake the inviolable character of the confessional. Article 5 declared that, quote, all criminals shall have the same privileges of witnesses and counsel as their prosecutors. Exclamation point. Every person charged with treason, murder, felony, or other capital offense should be admitted to have full defense by counsel, learned in law. Notice and hearing are preliminary steps essential to the passing of an enforceable judgment. I wonder if the lawyer or if the judge knows these things. I didn't he probably was like, "Wait a minute, I have to wait to sentence you until I adjudicate you?" These are new things. Sarah Boone, the more you know. Notice and hearing oh, where were you? And they, together with legally competent tribunal having jurisdiction of the case, constitute basic elements of constitutional requirements of due process of law. The words of Webster, so often quoted just by her. Thor, what are you doing? There is no food up here. I don't know why you continue to just try to climb on this desk, but okay. In the words of Webster, look, Webster is going to send you a cease and desist, Sarah, and I'm going to feel really bad for you when you have to pad your letters out with something other than definitions. Let's see. Constitute basic elements of constitutional requirements of due process of law. The words of Webster, so often quoted, that by the law of the land is intended a law which hears before it condemns. Thor, stop. For the love of all that is holy, Thor, down. No, not desk, down. Now there's going to be just Thor hairs everywhere. Judgment without such citation and opportunity wants all the attributes of judicial determination. It is just judicial usurpation and oppression. And if anyone knows anything about oppression and being denied my rights, I have been here for 4 years. That's like 11 jillion weeks, 100,000 million hours, and 5 minutes since I lost freedom. Oh, Webster was a TV show? I thought even the intelligent, educated layman has small and sometimes no skill in the science of law. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise unadmissible. He lacks both the skill and knowledge adequately to prepare his defense, even though he may have a perfect one. He requires the guiding hand of counsel at every step in the proceedings against him. Without it, though he may not be guilty, he faces the danger of conviction because he does not know how to establish his innocence. If that be true of men of intelligence, how much more true is it of the ignorant? And I'm intelligent. Like, I am the most intelligent person I know. Again, I do puzzles and painting. I am like classy, super classy. It was a Van Gogh painting, okay? Starry Nights. So I was trying to bring Jorge a little, culture and stuff. So, I mean, really, I am super smart. but I still don't understand the law. If any case, civil or criminal, a state or federal court were arbitrarily to refuse to hear a party by counsel, it reasonably may not be uh, doubted that such a refusal would be a denial of a hearing, competency, and therefore of due process in the constitutional sense. The decisions all point to that conclusion. Pointing to the fact that the right of counsel, as secured by the Sixth Amendment, relates only to criminal prosecutions, Judge said, quote, but it's equally true that the provision was inserted in the Constitution because the assistance of counsel was recognized as an essential part to any fair trial of a case against a prisoner. In Ex parte Riggins, CCA 134F 404 418, again, she's using the same cases. So, but it still revolves around the 14th Amendment, which I don't think she has a problem with here, but I'm not a constitutional lawful law person. The court said, by way of illustration, that if the state should deprive a person of the benefit of counsel, it would not be due process of the law. Judge Cooley refers to the right of a person accused of a crime to have counsel as perhaps his most important privilege. And after discussing the development of the law upon which the subject says, quote, with us is a universal principle of constitutional law that the prisoner shall be allowed a defense by counsel. Again, ma'am, you had 9 chances. 3 of those were not your fault. 4 of those, hell yes, were. And no, Thor, please walk right on the keyboard. Or just sit on it. No, not on the Thorberto. All right, you can sit on my lap, you 900 pounds of cat. Again, how are you honestly so oblivious to your own thoughts and your own faults that you are legitimately surprised when things happen to you like this? How disconnected is she from cause and effect and correlation to not understand that she is in fact the cases that these are fine. These are, things, cause and effect. It's not like it's all the suddenly. It's not like in, a rare epiphany, all these lawyers decide to just up and quit. It is amazing how she is so oblivious to the fact that she is a self-centered C word. The necessity of counsel was so vital and imperative that failures of trial courts to make effective appointment of counsel was likewise a denial of due process within the meaning of the 14th Amendment. All that is necessary now to decide, and we do decide, where the defendant is unable to employ counsel and is incapable of adequately making his own defense because of ignorance or inexperience, like it is the duty of the court, whether requested or not, to assign counsel for him as necessary, requisite of due process of the law. And that duty is not discharged by an assignment of at such time or under such circumstances as to preclude the giving of effective aid in the preparation and trial of the case. To hold otherwise would be to ignore the fundamental postulate already adverted to, quote, that there are certain immutable principles of justice which inhere the very idea of free government, which no member of the Union may disregard. Holden versus Hardy supported a case such as this. Whatever the rule may be in other cases, the right to counsel appointed when necessary, thank you, Thor, is a logical corollary from the constitutional right to be heard by counsel. Compare Carpenter and Sprague versus Dane County, 9 Wisconsin 274. Make yourself right at home, Thor. Just right at home. No. Dane County versus S. Smith, Wisconsin, 585, 586. Hendricks versus State, 130, Indiana, 265, 268, 269. Let's see, Cutts versus State, 54, Florida. People versus Goldson, 67 or 76, California. And Delk versus State. Thor, you are too big to go under the microphone thing. Would you stop romancing my computer modem thingy mabobber CPU? I am not sure that you should be rubbing on that like that, Thor. Thor is deeply in love with the Alienware tower, and I don't know how to tell him that it's a computer tower and doesn't love him back. In Hendricks versus State, Supra, there was no statute authorizing the assignment of an attorney to accomplish the ends of public justice, and that court possessed the inherent power to make it, quote, where a prisoner, the court said, page 296, without legal knowledge is confined in jail, absent from his friends, without the aid of legal advice or means of investigating the charge against him, it is impossible to conceive of a fair trial where he is compelled to conduct his case. Thor, you are on the mic. You are... All right, just not on the mouse. Give me the mouse. Thor... Yes, really, Thor? If it's not the kids, it's the cats. I swear. Let's see. Charge against him, it is impossible to conceive of a fair trial where he is compelled to conduct his cause in court without the aid of counsel. Such a trial is not far removed from an ex parte hearing. Let us suppose the extreme case of a prisoner charged with a capital offense, unable to employ counsel with the whole power of the state arrayed against him, prosecuted by the counsel for the state without assignment of counsel for his defense, tried and convicted and sentenced to death, PBL, such a result which, if carried to or into execution, would be a little short of judicial murder. It cannot be doubted would be a gross violation of the guarantee of due process of law, and we venture to think that no appellate court, state or federal, would hesitate to so decide. Okay, Sarah, they are not taking away your rights. This is called cause and effect. You effed A'd and you FO'd. It's not a thing where, and suddenly all the confusions I don't understand. You had access to lawyers. You refused to listen to learned attorneys. You decided you knew best. And now you know best. You are your own attorney. You should be proud and happy because you don't trust anyone but yourself. Quote, no, the legislator has become so thoroughly convinced of the impropriety and injustice of shackling and restricting a prisoner, which with respect to his defense, that they have abolished the odious laws, and every person, when he is accused of a crime, is entitled to every possible privilege in making his defense and manifesting his innocence by the instrumentality of counsel and the testimony of witness. Powell versus Alabama. H. In long line of cases that includes Powell versus Alabama, Johnson versus Zebust, Gideon versus Wainwright, this court has recognized that the Sixth Amendment right to counsel exists and is needed in order to protect the fundamental right to a fair trial. The Constitution guarantees a fair trial through due process clauses, but it defines basic elements of a fair trial largely through several provisions of the Sixth Amendment, including counsel clause. quote, in all criminal prosecutions, the accused shall enjoy. Okay, Sarah, I'm guessing, and I could be completely way off course here, but I'm guessing that the judge knows what what Florida's stance on having defense counsel is. I think that you copying word for word dissertations of smart professors that wrote books a couple years back does not prove your point. All that proves is that you can copy and paste in handwriting, which is great, but that doesn't mean you comprehend these things. That doesn't mean you have the understanding of what these legal terms actually mean in practice versus, what the common parlance of these, words mean. So you also, again, meet consequences. Let's see. Uh, this Thus, a fair trial is one in which evidence subjects to adversarial testing and is presented to impartial. Do not eat cords. What is wrong with you and Dingus? No, off the table. No eating cords. Is presented to an impartial tribunal for resolution of issues defined in advance of the proceeding. The right to counsel plays a critical role in the adversarial system. Sarah, if there's one thing at least you have nailed, it is the adversarial system. You give yourself a gold star for being adversarial. Embodied in the Sixth Amendment, since access to counsel's skills and knowledge is necessary to accord defendants the ample opportunities to meet the case of the prosecution to which they are entitled. Adams versus United States, X reference McCann, and Powell versus Alabama. Because of the vital importance of counsel's assistance, this court has held that, with certain exceptions, a person accused of federal or state crimes has a right to have counsel appointed if retained counsel cannot be obtained. See Arsinger versus Hamlin and Wainwright Supra Johnson v. Zerbist. That a person who happens to be a lawyer is present at a trial alongside the accused, however, is not enough to satisfy the constitutional command. The Sixth Amendment recognizes the right to the assistance of counsel because it envisions the counsel playing a role that is critical to the ability of the adversarial system to produce just results. Sarah, I'm talking to you as a serious person now. If the state would come to you with a plea deal of reckless homicide, you should probably take that. My guess is your personality and your general cuntitude is gonna get you the DP, okay? They're gonna bump the jury is gonna bump you up to murder 1, okay, because of your attitude. So I'm saying if they offer you a plea deal, I would go with it. Also, I'd make a really interesting accountant. I also feel a bit like Dennis the Menace's dad in the cartoon. Her hair is insane. Let's see. The accused is entitled to be assisted. Oh, no, I already did that. Federal Rules of Criminal Procedures, United States Code 2024 edition, Section 44, right to appointment of counsel. 9, or no, that's an A. She's getting a whole lot cray-cray in her writing style, so I believe that's an A. Right to appointed. A defendant who is unable to obtain counsel is entitled to have counsel appointed to represent the defendant at every stage of the proceeding from initial appearance through appeal. Unless the defendant waives his right, defendant has been forced to forfeit her rights to counsel from one-sided lies and unrequested misrepresentations. Like Sarah requested misrepresentations. For understanding, intervention for remedy was not removal from the defendant to the court. Yeah, Judge, Kranek, I was telling you to tell Miss Cashman to respect my authority, not to take her away. I mean, you were supposed to yell at her and stuff. I sent you a letter with all the mean things she's been doing to me. Or B, appointment procedure. Federal law and local court rules govern the procedure for implementing the right to counsel. Notes of adversary or advisory committee on rules, 1944. This rule is a reinstatement of existing law in regard to the defendant's constitutional right of counsel defined in recent judicial decisions. The Sixth Amendment provides, quote, in all criminal prosecutions, the accused shall enjoy the right to have assistance of counsel for his defense. Sweetie, this would be really good, except for the order that the judge wrote out, basically documented all of your bullshittery and, effery with every single lawyer. Uh, I don't think that the judge takes, lightly his need to take your counsel away. So he dotted every I, crossed every T, and he is ready to go. You are not going to get away with, having these meltdowns because you had uh, what was absolutely competent lawyers. They just weren't going to go along with your cockamamie, defense. She really should be misrepresentation. Yes, Thor is back. He knocked over a light. He's made a lounge place for himself on the table next to his uh the love of his life, the computer tower. He's like, I just like the gentle glow of the lights of Alienware. Uh, thank you so much for the super sticker. And let me see what that is. Because Thor, did you move everything? Yes, you did. If it's not the cats, it's the kids. If it's not the kids, it's something else. Thank you for that. This is a lot of words to say. I effed up and please give me another lawyer because the Constitution tells me, Your Honor. And I really didn't think that consequences applied to me. And how dare you? Uh, yeah, absolutely. Old line read, Your Honor, I totally misunderstood what you meant when you told me I wouldn't get any more lawyers if I kept acting like an a-hole. I mean, you are really unclear and subtle, and I don't deal like I am a very literal person because I am compos mentis all the time. So, Your Honor, you should have been really clear that I was not going to get another lawyer because I was not made aware of this. It really is unfair. 18 USC, former subsection of 563, now subsection 3005, which is derived from the Act of April 30th, 1790, provides every person who is indicted of treason or other capital crimes shall be allowed to make his full defense by counsel learned in law in the court before he is tried, or some judge thereof shall immediately upon his request assign to him such counsel, and they shall have free access to him at all season or reasonable hours. The present extent of the right of counsel has been defined recently in Johnson versus Zerbst, 340 U.S. 458, Walker versus Johnson, Glasser versus United States. The rule is a restatement of the principles enunciated in those decisions. See also Hofzoff, J. Quote, when a society acts to deprive one of its members from his life, liberty, or property, it takes its most awesome steps. No general respect for, nor adherence to, the law as a whole can be well expected without judicial recognition of the paramount need for prompt and eminently fair and sober criminal law procedures. The methods we employ in enforcement of our criminal law have aptly been called the measures by which the quality of our civilization may be judged, the United States Supreme Court. Well, I'm sure that the judge doesn't know anything about the Supreme Court, Sarah. Thanks for bringing it for his, his perusal. I'm sure he'll be really interested. And here we come to her conclusion. I'm going to see if you guys can see this. Do you see what I'm dealing with? Sorry for the shaky cam. No, Thor has just taken his own little place on my desk. Passed out. He's like, I love you, computer tower. Be my best friend. Now her conclusion. Wherefore, Sarah Boone, that's me, pro se, indigent, but still independent and fierce. Respectfully requests the Honorable Court to provide immediate relief to the defendant by appointing effective standby counsel. I mean, could you take your darts of justice and maybe take off the blindfold just a little bit? Also, I'm still asking about my alimony. Does anyone know where my ex-husband is? I have been trying to find him forever. I even added that to my private detective, list of things to do. Also, with him finding me a lawyer that can do something in the state of Florida. Let's see. Respectfully request the Honorable Court to provide immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. The defendant is requesting collaboration, correct understanding, and overall perspective of her extraordinary circumstances by rendering her cognitive incapabilities. Sarah, you can just say you're dumb. You can just say you're uneducated in the law. Procedural inabilities and extremely limited capabilities altogether as fact, and concluding a remedy of assistance is rightfully needed to be provided to the defendant by the court. This might be the first time that Sarah has admitted a fault. I mean, of course, it's in a roundabout way. It's a situation outside of any of her control that was just forced upon her, because, well, she's a terrible, horrible human, but she's like, I really do need this. I am incapable of doing the law. As smart and as men's alike as I am not able to do the law. So really, it's your fault. Appointment of vital standby counsel will lessen greatly her probabilities of further loss, damage, hair loss, resting bitch face, passive aggressive vocabulary, and sending of letters, and oppression in her criminal case. Fair and equal position by fair and equal opportunity will also be greatly enhanced. I thought this was America. I thought I lived in America. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, and thrive and overcome her forced by the court proposition of pro se attorney and her representation of self. Oh my God, that wasn't her conclusion. Dear God, this is her conclusion. This motion for immediate relief to the defense by appointing effective standby counsel to aid and support in the preparation of her case for a fair trial should be granted. I mean, I even sent you a little letter that says check yes and yes. And all you really do is check yes. And I'll just take it as a blanket oath that you think everything I do is okay. And I'll go from there. Oath. Under the authority of subsection 920 or 92525 Florida statute and state versus Schreiner, The defendant makes the following oath under the penalties of perjury. I declare under penalty of perjury that I have read the foregoing document and the facts and matters stated above are true. Oh, and she even put a service thing on this. Isn't that special? She didn't include a map of the people that love her. I did not realize how long these are. I am planning on getting some stuff, slow cooking for date night. I thought I was gonna be able to get through both of these. Let me see how long the next one is. The next one is 20 pages. So what I think I might do is, do a Sarah Booning tomorrow, a drive-by lawful lawing tomorrow by Sarah Boone, because I am running out of time so that I can get the house somewhat cleaned up so Mr. Mo comes home to a clean house for date night, which now don't get too peanut butter and jealous. I mean, we're probably gonna sit down and watch a movie, uh, but, romance is different after 14 years. Oh, and happy birthday, Wolfram. I didn't see, that it was your birthday, so have a wonderful, wonderful birthday. It was a fairly short one. Uh, oh my gosh. I hope Mark Feathers please let me represent again. All I get to do is I go to Florida, you let me buy a couple wigs, new wigs, and all that I ask to represent Sarah is that I want 2 Yeti coolers, and I want them summa bitches filled up to the top with Diet Dr. Pepper, which I don't even really like, but I will speed pound those like the prosecutors from the Theodore Edgecombe case right in front of her. All the Diet Dr. Peppers. I will just open one, chug it, and then get another one. I don't care if I have to use the restroom 173,000 times a day. I just want to have a bunch of Diet Dr. Peppers, and drink them in front of her, and a whole cake, and maybe just inform her at the end of her case that I'm a YouTuber. Could you imagine if I came in as Sarah to be her lawyer? I just show up with this wig on? I would do it, you guys. I'm 40, I'm married, Mr. Mo's stuck with me. I mean, I don't mind going out in public looking like Sarah Boone because I can always change. Well, Thor and I thank you for joining us today, and I'm guessing I'm gonna have to get him a little bed, so he can sleep on my desk next to his lady love computer tower, and we will see you guys tomorrow for some more Sarah Boone-ish more Sarah Boone Motion-splosion. Have a lovely day, and I will not be on tonight because it is date night, but I will see you with all of the newsy news, nuggets, and political news, and fluffy to fit news tomorrow. So I will see you guys then. Thank you guys so much for joining. Like, subscribe, and share all of the YouTube stuff, and have a great day. Bye, guys.